ahead and get started, guys. Thank you once again for joining us.
Absolutely.
Today is Thursday, May 14th. And today we have with us the fabulous Christine Sensenig, who she has been on our webinars before. She is the labor attorney extraordinaire. We work with her quite a bit. We have a lot of mutual clients, a lot of clients we have referred to her, and vice versa. And she has just been an amazing resource for us to discuss any of the employment issues, the unemployment issues. And so I think Chris is going to touch on a couple of different things today. One of the, things that I guess we have all seen is people are going back to work, not going back to work, working remotely, not working remotely. And a lot of the employers are having a tough time with what is comfortable versus not comfortable. So we have asked Chris to definitely address some of these issues, but she will also give us an update on what's happening in the land of unemployment application. And Chris, I've got the PowerPoint, so if I need to move to the next slide, just holler at me and I'll move on. So I will turn it over to you.
All right, so I'm going to start off just briefly with sort of an unemployment update, and as we go through the slides, some of those issues will also come into play. But frankly, there's been no good news this week, in my opinion. What we have heard is that the people are going to have to start recertifying, that they're looking for jobs again every 2 weeks. And while that's not necessarily a problem or an issue, the problem is you can't get onto the Connect system to do it. Everybody I know who's trying to recertify or trying to get on to give an update, including people who, their employers have been fortunate enough to get PPP and they've gone back to work, maybe even part-time, can't get through to Connect to say, I've got my job back. The other thing that's really problematic is people who did get their jobs back through PPP and are now getting paid from unemployment. Well, that's not a problem because it's supposed to be backdated. Here's the problem that we're seeing. We have this notion of what dates they're putting on for pay. So you're getting a paycheck from unemployment that basically should have been from March, that's dated for the current week. They're working. So people are like, what am I supposed to do?
Yes.
Honestly, for me, what I've been saying is, you know what? They owed you from March. Just document you weren't paid in March. Keep it. And, eventually they'll realize that they've got their dates wrong, and maybe they won't. The other issue that is happening is that there was there's a couple of different members of the legislature that are taking this very personally. Senator Jason Pizzo and Senator Jeff Brandes particularly have been really trying hard to get some cooperation with not necessarily just the governor's office, because they're trying. I mean, they do appear to be trying to keep hiring staff, to keep hiring people. But it appears as if a lot of the people who are responding to the calls are not trained. So people are getting crazy denials. They're being told, well, you're denied because you didn't pay your rent. That has nothing to do with unemployment. They're being told, well, yes, you worked for 3 years for that employer and made $50,000 a year, but you don't have enough base earnings to qualify for your quarter. That makes no sense. It's totally incorrect. So people are really trying hard to reach the Connect system, reach the DEO, and it's just not seeming to work. I can tell you that they have continued to process more claims in the past week at a pretty brisk rate, but I think they said the denial rate was in the 30 percentile, which is a big problem because 30% of people applying for unemployment are not ineligible for unemployment. So, like I said, there's really not a whole lot of good news there because based on this recent expose that was done where they had some people call to ask about, why they were denied, just so they could write down the responses. And yes, the denials were not legitimate, but they did it to get well, what about this and what about that? Somebody was routed to a supervisor and the call came back to the exact same person you were talking to.
Wow.
Who went, Yeah, I'm not a supervisor. I just talked to you. I don't know why they sent that to me. They're like, well, they told me you were, and they told me this is the number I should call. So I bring that up so that you know you're not alone, and that it is extremely, extremely frustrating. And that what we're hearing is to please go ahead, and even though they can't do a whole lot, the compiling of the numbers, as far as how many people are calling, how many people are having problems, is helpful for the local representative, which in our area for a lot of people is Margaret Good. And a lot of people are reaching out to Representative Pizzo and Representative Brandis simply because they've kind of taken the lead on this issue and are trying hard to have an opportunity to compile these lists to bring it to Senate President and say, people need help. I don't think there's a lack of understanding that people need help. I just think that the million claims is so problematic for the system that the response is, well, we'll eventually catch up. But when you haven't gotten a paycheck for 7 weeks, that doesn't exactly help. They still don't have the portal for direct access to the $600 federal pandemic payment in a position where I could say it works. I know some people who've gotten their $600 payment. I know many people who tried to use the portal who would be eligible as self-employed or eligible as part-time who can't get it to work. And they were denied, and then they reviewed, and then they were denied again, but they can't get the telephonic hearing. So the system still remains in chaos. So I just kind of bring that up to let you know you're not alone.
Can you tell me what's the latest for the self-employed individuals? Should they still keep applying and getting a denial and getting a call back, or what's the process there?
Interestingly enough, they did, DEO issued yesterday, because they're issuing things after hours, so sometimes it's kind of hard to know whether they consider that yesterday. But they said you need to call them. Like, really, good luck with that. And what I will do, Marina, is I'll forward that to you so you can put it on the website. As far as the number that they've said you should be calling, I'm going to be honest with you, I know of no one who's gotten through. But that is the number they have said as a self-employed person you should be calling regarding your denial.
Wow. So you're encouraging for people to still submit the application, get the denial, and then call the number. Yes, if you can share that with me, we'll definitely post that on the website, because we're still getting folks with questions on that.
And again, I mean, I don't know how valuable that is because it's a number, and we all know, you spend hours trying to get through, but it's still the notion of they're putting more people on that particular task. They're hiring temporary staff to be able to do it. And the word on the street is that they are compiling those separately so then they can send this massive $200,000 stack to the federal government, which again is much more equipped to handle that level of data.
Mm-hmm.
Remember, let's go back to 2008 when we had the extended unemployment. That system existed. So they can still use those algorithms. They can still use that system to process 200,000 applications, while Florida cannot process 200,000 applications at any sort of speed. But I will definitely send you that, because it was just, maybe it was Tuesday night that they issued that number and said this is what you should call, as well as the commentary from one of the legislators on, great, they can spend 9 hours trying to dial a number that no one's going to answer. Thanks. But
Mm-hmm.
you still, when they give you the system, you have to at least demonstrate you tried to follow it, because what we're finding, which is extremely frustrating, is when you're trying to appeal the denial, you're not getting notice of how to appeal it for the telephonic hearing. So if they later say you didn't deny it, you didn't file the appeal in time, you will have the good faith response of being able to say, this is the number of times I called, this is the times I sat on hold, this is the times I was hung up on. Because if you have a good faith reason that you were not able to timely appeal, they will accept that. But good faith, documented, just you writing it down, I called. So I think logs are very important right now. And even though, like I said, it's going to be an exercise in futility, it will help you if you get well, you didn't appeal it in time. Or even though they didn't tell you how to appeal it, you'll be able to say in good faith, this is what I did, and therefore I deserve to go to the next step. So there's kind of the update there. I know last time I was on, I talked about the fact that there was a class action that was trying to go forward in Tallahassee. The judge turned it down because they said that using, number one, they were using a mandamus, which is a legal procedure that it's difficult to use. But the problem was the three people who were suing had gotten their payments. So they weren't standing anymore. And of course, the attorney's like, but I have, 78,000 more people on the list. They're like, well, you have to refile. And of course, by the time they refile, those people are going to have their payments because I'm sure magically they get their payments. But that's neither here nor there. So let's actually go to some of the other issues on a more, shall we say, optimistic topic of return to work. So when we look at the various issues facing employers and employees, if we look at today's agenda, which is the next slide, these were the topics I thought would be good to just talk about in general, which is a very, very important topic for everybody, is employers and social distancing. So PPE in the workplace, people wearing their own masks, things like that, just employee wellness in general, addressing fears about returning to work, remote work issues, which are huge, and of course, employee travel. So, there's Joanne. And Marina, when you get a chance, go to the agenda slide just so everybody can see it. And then we're going to talk just in general about something that I think we're all pretty aware of which is social distancing. So let's talk about social distancing in general. We're all aware of the 6 feet rule. I think we've all seen some pretty hilarious memes of different ways that people are trying to, and go on to the next one, trying to keep their 6-foot radius. My favorite is the gentleman in Home Depot with pool noodles sticking out of a hat he created because he said that way people are going to be 6 feet apart from him. We have all had the experience of having people too close to us that we don't know. At the same time, in the workplace, it's a whole lot easier for people to not only respect social distancing, but to sort of set up some physical barriers to do so. So we're all aware of the 6-foot rule. So on the next slide, it kind of shows a little bit of an example of 2 people and having their chairs apart. So Marina, if you want to switch to that one. This is, again, for employers, you really want to make sure that not only do you have policies and procedures in place, but if you take a look at the next slide, Marina, where you have somebody at a table, somebody at a chair, you've got a 6-foot barrier being represented. How do you keep that 6-foot barrier? People are going to get lax and slack because they're going to get comfortable. So how are you going to maintain it? So when you take a look at the next slide, Marina, with the 2 people in the chair and the desk, what do we do? What do we do to make sure that it stays that way? Let's do something simple. Let's talk about masking tape on the floor. Let's talk about putting a line. Let's talk about putting an X on this is where the chair stays. Because anybody who has a waiting room, whether you're a doctor's office, whether you're a real estate office, whether you're an attorney's office, an accountant's office, we all had kind of figured out how to make our offices pretty. And we had put, things in a way that was aesthetically pleasing. That doesn't work anymore. We have to remove chairs so that people don't have that tendency to say, well, but the chair's there, I'm just going to sit down next to the person. You don't want chairs that are 2 feet apart, because that's what's going to happen is people are going to immediately sit in those chairs because they figure they're there because you put them there for them to sit in. A lot of my clients have just taken chairs out of their waiting room because their answer is, I'm only going to schedule people so that there's only this many people in a room at a time. But if we even just look at this example, what's going to happen is he's going to get up and move, and that table's going to move, and she's going to move, and that chair's going to move, and you're going to be 4 feet apart. Next thing you know, you're going to be 3 feet apart. Those are sort of simple things that we can all do. And again, painter's tape, masking tape, stick it on the floor. So that way you've got sort of X marks the spot on this is where we should be. Those are some of the easy things you can do. The other thing that people have done is when you have a waiting reception area, they've kind of put a box on the floor. They kind of put either had professionally done with graphics, but sort of a please stay here. And so that way, if people violate it, which a lot of people are doing, not on purpose, but let's be honest, we haven't seen each other in a while. I mean, we've seen each other like this, but we haven't seen each other. So you walk in and you see somebody, first thing you do is put the hands out. You want to touch them. We miss that. So that's why you really got to have that sense of, no, stay in the box. So you've got to give people some sort of direction and dialogue. Where this also gets complicated and where I'm hearing the most concerns from my clients is related to kitchens and break rooms, because those are usually small anyway. They're meant for people to be close together, have a cup of coffee, have a chat. People are having to take chairs out of their break room, tables out of their break room, and basically put a sign up of, no more than 2 people in the break room at a time. So of course, what does that mean? You have to deal with scheduling issues. So even though breaks are not mandatory in Florida, please keep that in mind. They are not mandatory in Florida unless you have a union contract or unless you're like an EMT or a certified registered nurse anesthetist. These are all voluntary things. And again, they're good things to have for your employees, but you've got to keep them safe at this time. And we're going to forget because we're going to want to reach out to test somebody. So the answer is, even if you have to schedule it, people on the left side of the office, you can have a break from 10 to 11. Just make sure there's no more than 2 of you. People on the right side of the office, same thing. These are things that people can do that are simple, not draconian, not to the point that people feel uncomfortable or go, why do we have to do this? Is it that unsafe in the workplace that we have to have all these rules? Well, rules are there to keep us safe. And the one thing they've shown is, with contract tracing and all that sort of thing, it's important for people to stay away so they're not breathing on each other. So those are just some of the easy things that people can do. And if your employer isn't following those guidelines, then you might want to bring your own tape and say, well, this is my 6 foot and this is where I'm going to stay. Or, just as people start to walk into your office door, say, wait, let me have this conversation from there. People have habits that are going to be hard to break. So it's going to take reminders. A whole lot easier in a professional office where you can remove chairs, you can schedule people a lot easier. But when you're serving the public, like hair salons, nail salons, they've got a whole different set of regulations that they're going to have to deal with. And again, this is a personality-driven sort of issue. When you are in a public-facing role, you are used to being closer to people. It feels weird to be shouting at them 6 feet away. But that's why putting boxes on the floor, making sure you remove chairs. And even then, I've told my clients who have waiting rooms that, put a little small piece of masking tape every 6 feet apart. So when those chairs start to migrate, because they will, you can then go, nope, that's supposed to be in the middle and push it back. These are just simple things that we know work. So let's talk about.
Hey, Chris, before we move on, can I interrupt you with a quick question? The lawyer in me is fiending about liability. Can you talk a little bit about your perception of if these social distancing and masks and hand washing and hand sanitizer stations are guidelines or recommendations, or are they requirements? And either way, would the employer be liable for failure to have tape on the floor or have these type of precautions in place?
That is a really good question, Joanne, because industry specific.
Mm-hmm.
It is absolutely required for your hairstylist to wear a mask. DBPR issued the regulations for them last Saturday. And even though you as the client aren't necessarily required by the state of Florida to wear a mask, the hairstylist, the barber, the nail tech is. That's a rule. Now, talk about an accountant's office, an attorney's office. There's no rules for us that we have to wear a mask. There aren't. And a lot of people don't like them in that kind of environment. They feel uncomfortable with them. They feel it muffles the voice. And, again, we hear about all our first responders. We hear about our nurses and our doctors, and they talk about how uncomfortable they are and how difficult it is to wear them for 8 to 10 hours a day. A lot of people are like, okay wearing them to Costco or Foods to pick up their curbside delivery, but they aren't okay with wearing them for 8 to 10 hours of work. Barbershops, salons, of course, in the medical profession, mandatory. There are a few other areas that are governed by OSHA that they were already required to wear them for safety reasons when you consider dust particles, silica, things like that. But those were in place well before we had the pandemic.
Sure.
Let's go to the notion of, well, let's say we're in an attorney's office and we don't require our staff to wear masks. Again, we've got social distancing in place, left side of office, right side of office. And one of the staff says, well, I got COVID because, well, number one, there's going to be legislation most likely regarding that issue. But here's where I take sort of a lesson from the world of workers' compensation.
Mm-hmm.
In that, in order to claim that you got SARS, H1N1, Ebola, bird flu, from your workplace, you had to prove with an epidemiological study that that's where you got it. So considering that the only place we go to is not work, there is not a person out there who has not been to a Walgreens or Publix in the past 2 months. It may have been once, and they've been other Instacart and all that sort of thing, but most people have had at least one other interaction with somebody else. So how that workplace is the sole source of COVID-19. Again, in the medical environment, I think it's going to be a lot harder to say that, well, I work in ER and I got COVID, I wonder how. But I do think that when you look at, liability insurance coverage, viruses are usually excluded. Of course, we're dealing with business interruption coverage complaints as well. A lot of them do actually, crazily enough, have virus exclusions in them. And then in the world of workers' compensation, if your employee makes a claim, they will then say, well, give us the study by an epidemiologist, which, by the way, they're all employed right now by the federal government. So good luck in finding one. I'll tell you, I went through those ones, and it was a $35,000 bill. And that bill is not paid by the employer. It's paid by the person who's asserting that the exposure happened at the workplace. So do I believe there are going to be claims? Yes, I do. There's some good plaintiffs firms out there who are looking at these and going, maybe we could make money off of this, as well as possibly address a wrong, which is you in the workplace, you didn't keep your employees safe. By the way, what policies did you publish about enforcing social distancing and letting people know about how you were going to schedule them and how you were going to have hand sanitizer stations? And oh, by the way, did you have hand sanitizer? Those all sort of fold up into sort of the same thing of what are you doing to protect your employees and what have you done to demonstrate to them that you're continuing to protect them? So it goes back to one of my favorite phrases that Joanne and Marina are very familiar with. What policies and procedures do you have in place? If you don't have policies and procedures in place, you get something in place pretty quickly. It doesn't have to be 17 pages. It can literally be, front and back of this is what we require of you. When you walk in the door, you need to use the hand sanitizer. When you leave, you need to, make sure and take the Lysol wipe with you to wipe the hands. Go. Just, basic little things that we know we're supposed to be doing when we have a public space. Now, again, in looking at some of the legislation, as well as looking at some of the OSHA guidelines and things like that, the CDC has a recommended guideline. Absolutely good question there, Joanne. It's not mandatory. They didn't go to mandatory, even though they said it's recommended and suggested. It is not mandatory, except in, like I said, the professions that it is. So a lot of people are like, I don't want them in the workplace. And to deal with the germs that are associated with the mask, how do I know the person has cleaned it? I see some of the pretty fabric ones I've seen. Some people have an entire wardrobe of those. So, because again, you should use them and then wash them. You should use them and then wash them. And how do you know that people are? And how do you know they're not doing this? Grabbing it from the front, then putting it back on. Instead of grabbing it from the front to wash. We all know that that's bad, and that germs are going to continue to fly if you're going to continue to grab it and then put it back on. Because what have you done? Everything that's on the outside of that mask, you have now put on the inside by touching it, putting it back on your face, because we all know we're not supposed to be touching our face. So CDC recommended guidelines. There are mandatory guidelines, but remember, we're in an at-will employment state. Employers make the rules. So if the employer wants staff to wear masks, the employer can say staff to wear masks. The employer says they don't feel it's appropriate. for staff to be wearing masks? No, that's another battle that could happen. Then you've got to look at whether you're governed by the ADA, 15 or more employees. If you're in the city of Sarasota, 5 employees will get you covered by that. You also have to deal with the fact that how do you know that proper protocol is being used? If a person has the same mask every day, you're dealing with germs in that way too.
Mhm.
So this is again a policy and procedure issue. You need to be consistent. You need to decide what you're going to do. If it's going to be if you feel more comfortable wearing a mask, feel free to do so. It's not mandatory. You can do that as long as you're not in a mandatory profession.
Okay. We have one more question that's come up, and it says, what about the PrEP Act and blanket immunity involving a virus? Are you familiar with that? Because I'm not.
I'm not familiar with that, but just think about the fact that Congress passed sweeping legislation, 400 something pages, passed another set of sweeping legislation, and passed the whole Small Business Loan PPP Act in a period of less than 45 days. Whatever else is out there, they're talking about modifying right now anyway.
Mhm.
The notion of blanket immunity, there's not a law firm I know of that's not going to try to walk through that.
Yeah.
Mhm.
Your friends at Morgan & Morgan are busily
Well,
being
and
forced to people.
I just want to throw in here too is I'm thinking about our clients and our small business clients where their employees, it's like their family. So even if there may not be legal basis or you're not required to do something, or it would be devastating if one of these employees, let's say you've got a company with 7 people, if one of them gets sick and is even suspectful that they did catch it in the workplace, I think it's for the whole environment, for the employer, it would be just devastating to have something like that, even if it's a complaint that's filed or the employee comes up to the employer. So I think that even if things are not required, you have to take another step and say, okay, as I want to protect my employees, I want to protect myself as the employer. I just, to kind of minimize this opportunity, I think it's wise and prudent to take the extra steps. That's how I would envision it.
Like you said, for the small employers, because I mean, I can't even imagine what it would be like for me to try to do my job without my paralegal.
Mm-hmm.
She, for 10 years, she is my right and left hand. I would be devastated if anything happened to her. So I tell my clients, particularly right now, I said, it's one of the few times I can say the shoemaker's daughter does have shoes. I'm practicing social distancing. I'm not saying, oh, well, you need to do this, but I'm not. We are working remotely. We go into the office at different times. We scheduled it. Well, I'm going to be there from 3 to 6. I'm going to be there from 12 to 2:30. I'll leave whatever I need to on your desk. And even when we have that 6 feet apart at a conference table, where she's on one side of it, I'm on another. We want to be able to do these extra things to keep the people we care about safe. And like you said, we'd be devastated if someone got it because we were being slack, we were being lax. We didn't do some simple things. And again, now hand sanitizer is becoming available. Is it becoming available in the quantities we need? No. But for smaller employers, it's going to be easier to say when you walk in the door, you sanitize your hands. There's the wipes beside the door, different things you can do to keep it safe, and including, like I said, simple things of scheduling. Of okay, break room is from 10 to noon for this side of the office,
Mhm.
and that side of the office. It's weird because you can see each other, and it just seems hug them, touch them, get close, and ask. As you're getting a cup of coffee, pour somebody else one. Right now, it's like don't touch their stuff, and so this notion of personal protective equipment, the PPE. I again think of the salons and spas that are opening this week and going, where are they getting all the stuff? It's not that easy to get, and they're going to have to figure out how to wear that mask all day long and deal with fogging glasses and everything else. Again, it's what our medical professions have been doing for a long time, but they're in a way a little bit more used to it than those of us who work in an accounting office or an attorney's office. So now I got to do what? So
They're more skilled at properly using that equipment. Like you said, someone's touching the outside of the mask, putting it down, picking it back up, then touching the coffee cup, returning your credit card, whatever. It's the medical people are a whole different animal because they're trained in that stuff properly, and this is random people doing their best, people genuinely trying to do good who might actually be doing more harm.
And I think it is, we're doing our best. And that's why, again, having sort of a laminated policy and procedure thing that you can give everybody and say, again, not to share, but, you know, keep it there. So when I remind you of it, and as the employer, I usually like to keep it so that, you know, you have 10 to 12 things on there telling what to do. Is go, guys, remember number 6. Remember, you're not supposed to touch a coffee cup and leave it on the table.
Yeah.
So, simple things that you can do. But, you know, this whole notion of wearing PPE in the workplace, there are requirements by OSHA. There are requirements that, again, if you're in the salon industry, spa industry, EBPR just issued what your requirements are. But everybody else is kind of going to look at what the CDC said, what EBPR has said, what Department of Health said, and that's also a good site to look at as far as beyond just looking at the numbers, which can sometimes be scary. They also have some good advice there on, you know, this is what we're recommending. And over again, we are hearing repeatedly, regardless of what news source you watch, 20 seconds of hot water and soap kills the virus that they know of. So we know that it's a whole lot easier to be able to hit that pump for the hand sanitizer when you walk in the door, but now that you've hit the top of the pump, who's sanitizing the top of the pump?
If you have questions, make sure you email us. If there's other topics you want to hear, please keep us posted. And thanks again to Chris for all of your time.
It was my pleasure. It's always a pleasure to work with Joanne and Marina.